Welcome to another Tomkins Talks, a short snappy summary of an interesting recent case in a format that's easy to digest whether you're in the office, at home or on the move. Today I'm going to look at the case of Fearn and Others and the Board of Trustees of the Tate Gallery. Here we go. Let's get started with the backstory. The claimants were the owners of leasehold flats in a block known as Neo Bankside on the south bank of the River Thames. Their flats were split into two parts. First, a general living space, and second, an area known as a winter garden. The winter gardens have floor-to-ceiling glazed windows, separated from the rest of the flat by double glazed doors. The developers envisaged these winter gardens being used as an indoor balcony, but all of the claimant flat owners had incorporated these areas into the general living accommodation of the flats. Opposite the block of flats is the Tate Modern. In 2016, the Tate opened an extension building called the Blavatnik Building, which included a viewing gallery with 360-degree views of London. It's estimated around 500,000 people use the gallery each year. The issue with the viewing gallery is that visitors can see straight into the claimant's flats. Visitors frequently look into the flats and take photographs, with a number being posted on Instagram. Some even looked in with binoculars. The Tate sought to address this by putting up notices, asking visitors to respect the privacy of the Tate's neighbours, and instructing security guards to stop photos being taken. However, the claimants were not satisfied and brought a claim for an injunction obliging the Tate to prevent visitors from using the southern walkway. The main point they relied upon was the viewing gallery unreasonably interfered with their enjoyment of the flats, such that it was a nuisance. So what was the outcome? At first instance, Mr. Justice Mann found for the Tate. Although he thought that in the absence of statute, the law of nuisance could possibly extend to protecting privacy rights in a domestic home, he concluded that the claimant flat owners were occupying particularly sensitive properties, which by changing the use of the winter gardens, they were occupying in a particularly sensitive manner. He suggested the claimants should consider options such as lowering solar blinds or installing net curtains. The claimants appealed. Well, as you may well have seen in the press, the Court of Appeal also found for the Tate, although for different reasons. It disagreed on the sensitivity issue and held that the correct test was to consider first whether the use of the flats was ordinary and reasonable, having regard to locality, and second, whether the viewing platform had caused material damage to the amenity of the value of the flats. If the answer to both of these questions was yes, there could be a liability in nuisance. However, for the claimant flat owners to succeed, nuisance had to extend to overlooking, and having reviewed a long line of authorities, the court concluded that overlooking does not constitute a nuisance. If privacy rights were to be protected, the court commented it should be a matter for Parliament to legislate on, as it had done in such areas such as data protection and stalking. So what does this mean? Well, the key takeaway from this case is that the court has undertaken a thorough review of whether overlooking could create a nuisance and has concluded that it can't. It's suggested it is a matter for Parliament to formulate any further laws perceived to deal with this issue, so watch this space. Please feel free to comment on or share this video, and do get in touch if you would like any more information on it. I'll see you again soon for another Tomkins Talks.